in the topic of trustees, this is the final topic that's known as disabilities of trustees. What we have studied up to now, the liabilities of trustees, duties of trustees, powers of trustees, rights of the trustees. Today in this lecture, we are going to see the disabilities of trustees. First of all, we will see section 48. Section 48 provides that a trustee who has accepted a trust cannot renounce it except with the permission of the court, if the beneficiaries are competent to contract with their consent, or by virtue of the special power as specified in the deed of trust. As specified in the deed of trust. Section 48 of the Trust Ordinance, as we have seen here, a trustee cannot renounce the office of the trustees. Generally, when you see the trustee's powers, a trustee cannot be compelled to accept the office of the trustees. It is an option to decide, or choice to decide to accept or disclaim it. In terms of section 10 subsection 2, no one is bound to accept a trust. There is no mandatory requirement to accept it. Section 10 subsection 4 provides that instead of accepting a trust, the intended trustee may disclaim it within the reasonable period, and such disclaimer shall prevent the trust property from vesting in him. Therefore, before the acceptance of the trust, the intended trustee is competent to renounce the office of the trustee or disclaim the office of the trustee. After acceptance of the office of the trustee cannot disclaim, and if he intends to disclaim, he has to do it before the acceptance. In terms of section 48 of the Trust Ordinance, upon the acceptance of the office of the trustee, a trustee is not competent to escape from the liabilities of the trustees by subsequent renunciation. However, section 48 lays down 3 circumstances under which renunciation by a trustee of the office of trust is permissible, as we have seen under section 48, paragraph A, B, C, with the permission of the court, if the beneficiary is competent to contract with his consent, or otherwise by virtue of the power, the special power is specified in the deed of trust. The trustee may seek the permission of the court to be discharged from his office. If he satisfies the court about the sufficiency of his ground for such discharge, the court may grant such permission to discharge him. In terms of section 74 of the Trust Ordinance, when you see the section 74 of the Trust Ordinance here, notwithstanding the provisions of section 11, every trustee may apply by petition to the court to be discharged from his office. If the court finds that there is a sufficient reason for such discharge, it may discharge him accordingly. But where there is no such reason, the court shall not discharge him unless a proper person can be found to take his place. And there is a substitution is also necessary for the purpose of discharging somebody or discharging a trustee of the trustee. The renunciation of office of the trustee can be with the consent of the beneficiary who is competent to contract, as we have seen in say, paragraph B. In terms of paragraph C of section 48 of the Trust Ordinance, if the instrument of trust specifically provides that a trustee may get himself discharged from the office of the trustee by appointing a new trustee, a trustee can make such appointment and get himself discharged. That is the section 48 in relation to the discharge after acceptance of office of the trustees. Now we will move to section 49 of the Trust Ordinance, that is in relation to the delegation of powers. Generally, when you see this piece of legislation, it is permissible, but in terms of Trust Ordinance, it is not. A trustee cannot delegate his office or any of his duties either to co-trustees or the stranger unless the instrument of trust so provides. The delegation is in the regular course of business. Delegation is necessary. Beneficiary being competent to contract consents to such delegation. Finally, if the court directs. These are the circumstances where the delegation is permissible. Otherwise, the general rule, that is prohibition of delegation of powers or duties to anybody. The Trust Ordinance section 48 and 47, similar to Indian Trust Act section 46 and 47. Therefore, we will see one of the Supreme Court case, Indian Supreme Court case in Sheikh Abdul Hayum case. In Sheikh Abdul Hayum case, the Supreme Court of India has interpreted the scope and application of both section 46 and 47 of the Trust Act in India. When you see in Sri Lanka, it is 48 and 49. The Supreme Court said as follows: there cannot, in our opinion, be any doubt about the correctness of the legal position that the trustee cannot transfer their duties and powers to somebody of men and create them trustees in their own place unless this is clearly permitted by the deed of trust or agreed to by entire body of beneficiaries. Entire body of beneficiaries. A person who is appointed as a trustee is not bound to accept the trust, as we have seen now. But having once entered upon the trust, he cannot renounce the duties and liabilities except with the permission of the court or with the consent of beneficiaries or by the authority of the trust deed itself. Nor can a trustee delegate his power or delegate his office or any of his functions except in some specified cases. The rules regarding the renunciation of the trust by a trustee and against the delegation of his powers by a trustee is embodied in respect of the trust to which the Indian Trust Act applies in section 46 and 47 of that Act. In Sri Lanka, that in terms of section 48 and 49 of the Trust Ordinance. As you have studied in your first year, this is something persuasive judgment in Sri Lankan courts. The general rule is that the office of the trustee, being founded as a relations of personal confidence, the powers and duties relating to it cannot be delegated. No trustee can delegate his powers and duties to another trustee, and any agreement to do so would be illegal and void and would not be covered by any of the exceptions in section 49. Even where a trustee executes a power of attorney for the proper and effective management of the trust property, the power of attorney holder shall be deemed to be a de facto trustee and accountable for the monies belonging to the trust. But mere management or mere arrangement for the management of trust is not alienation of office or delegation of duties. Mere arrangement for the management of the trust is not delegation of duties. If a trustee wants to make an authorization in favor of another trustee, it must be express, specific, and in the clearest of terms. Mere authority to an agent to negotiate for sale cannot bind the principal by entering into a contract for sale. There's a substantial difference between to sell and to find a purchaser. Once again, mere authority to an agent to negotiate for a sale cannot bind the principal by entering into contract for sale. There's a substantial difference between to sell and to find a purchaser. Similarly, mere fact that trustee have appointed one of their members as managing or executive trustee by a resolution in an ordinary way does not involve the delegation of power. Even otherwise, the majority of the trustees cannot elect one of them as managing director because the minority is ousted from taking a part in the management. There should be a unanimous decision or resolution. If the trust imposes an obligation upon the trustees to sell the trust properties at a highest price and to distribute the sale proceeds among the creditors of the author of the trust, they cannot leave the payment of debts of the creditors to the respective purchaser. That would be violation of section 49, and sales would be invalid. Likewise, where the directors of a trust fund have been given authority to purchase a house property, duty of which house to purchase cannot be delegated to a committee, but it should be done unanimously by all of the directors. Now we will see this case. Now we will see the admirant case here. In this case, the court held that if the trustees want to file a case or suit for the possession of the property from a tenant, all must join in filing a suit unless the trust deed otherwise provides. In Dulichan case, that another case, the Delhi High Court has held that if a suit is filed by one of the court trustees, even if authorized to do so by a resolution passed by other court trustees, suit will not be or would not be maintainable. Then we will see some other cases here. Kishore Yo case. A decree was obtained on behalf of a statue of a temple. Subsequently, a trust deed was executed, but under the deed, the president of the board of trustees could not by himself execute the decree. It was held that the president could not apply for the execution alone, and either all the trustees ought to have joined in action or they ought to have authorized him to execute it. All get together and authorize him to proceed for the execution of decree. The fundamental rule is that trustees who take on themselves the maintenance of property for the benefit of others have no right to shift their duty on other persons. But this rule has been relaxed in the interest of proper administration of trust. So a trustee may delegate his office or the duties in the case of specified in this section. Even so, while appointing an agent, the trustee must exercise his personal discretion in making his choice of the agent, and should not delegate the choice to someone else, though he may seek his advice or he may ask him to suggest some names of suitably qualified persons. Even where an agent is appointed, he may be employed to do so only that work within the scope of his usual business. That's the meaning of the exceptional cases. There must be a usual business. The course of business, it can be delegated. If there is a proper employment of agent, the trustee is not liable to make good such loss as takes place through any fraud or neglect of an agent, provides there is no misconduct or fraud on the part of the trustees themselves, and the trustees would be liable for loss caused to the trust property by default of an agent only if the agent was not a proper agent or if the trustees failed to supervise the agent properly. Whether settlor or testator had appointed a number of trustees, the intention is that all of them must execute the duties of their office jointly. That's why they cannot delegate to any other person. Therefore, the recognition of any delegation by a trustee to his co-trustee would defeat the intention of the settlor or testator. It is on this principle that the law prohibits the delegation even to co-trustees, because under express provisions of the trust that the trustee must act jointly and thus would debar the trustees to delegate the duties and powers of the trustees to one co-trustee. Now we will see this Adam case. In the Adam case, when an executed trustee allowed the trust funds to be invested in stocks by another person who dealt with the trust fund as an agent of the executed trustee and ultimately committed misappropriation, the trustee was held responsible for such misappropriation committed by the delegate of trustees. As in the other case, Pierce case, a retiring trustee conveyed the trust property to a person who was not validly appointed as his successor. The retiring trustee is held to be liable to the beneficiaries for the loss resulting by act or omission of such person. Manoharal case, that in another case, in that case what happened, the instrument of trust gave the power of appointing a trustee by a continuing trustees in the event of any vacancy. However, there was a difference of opinion of the continuing trustees regarding such appointment, which culminated in a suit for administration. Such suit was compromised, and in that compromise it was agreed that the powers of filling up the vacancies may be exercised by an outside board of trustees. It was held that the compromise amounted to delegation of powers of appointing trustees by continuing trustee and was invalid, and consequently the power to appoint devolved upon to the court. Delegation is improper because beneficiaries are entitled to the collective wisdom and experience of all the trustees. And if the trustee delegate the powers of the administration of the trust estate to a co-trustee, then they will be deprived of such collective wisdom and experience of all the trustees if the delegation to the co-trustee is permitted. Hence, such delegation is illegal. Where the instrument of trust, that's the trust deed, authorizes such delegation, the trustee can delegate his duties and powers. Where, for instance, the testator or settlor or the author of the trust has indicated a particular person to be entrusted with the business of the trust, it will be open to the trustees to entrust the business to such nominee. That we have seen as if it is authorized by deed of trust, then it can be done, it can be delegated. Where there are more trustees than one, it is permissible as a matter of convenience to dispute one among themselves to look after affairs of the trust, but legal responsibility, even in such case, will be of the entire body of trustees. The office of managing trustee is unknown in law. If the managing trustee is appointed by the trustees themselves, such managing trustee has the right to administer the trust property under the supervision of co-trustees, but he cannot act singly and has no power to create a lease which amounts to alienate of property. The trustees among themselves may make arrangement to carry on the business of the trust property or the trust, but that is their internal arrangement for their convenience. But in the eye of the law, all of them shall be liable for the acts of one or other of them. The explanation given to section 49 clearly lays down the appointment of attorney or the proxy to do any act merely ministerial and involving no independent discretion is not a delegation within the meaning of section 49. The acts requiring discretion of trustee cannot be delegated. So where he is required to exercise his discretion in the matter of authorized investment, he has to exercise such discretion himself. He cannot delegate such power to any other person. So he can appoint a valuer and consider his report as regards the stability of an investment. Even then, he has to decide alone the adequacy and the nature of the security and cannot merely adopt the opinion of the valuer. However, if the trustee has to select the valuer, for such purpose, he has to do such selection of valuer himself. He cannot entrust the duty of selection of valuer to his attorney. The power to sell or lease the trust property is a matter which a trustee has to decide by exercising his independent discretion and the fitness of the lease and the rate of rent to be paid by lessee and other terms and conditions have to be decided by the trustee himself. Even the granting of lease is a matter which requires independent judgment of the trustees and cannot be delegated to any other co-trustee or agent. Now finally we will see Solar versus Ashwell case. When the trustee executes a power of attorney for the proper and effective management and administration of trust property in favor of another who is not a trustee, such an agent is primarily responsible on an equitable principles. The trustee cannot also escape the liability if the full amount realized by the agent was not recovered from agent. It is observed that the court of equity will impose upon such agent all the liabilities of the express trustee and will class them as express trustee of express trust. that is the delegation of powers of the office of the trustee. The delegation of office of trustee is prohibited, and also delegation of powers, duties of the trustee is also prohibited, other than in the exceptional cases. Now we will see section 50. Section 50 of the Trusts Ordinance provides that where there are more trustees than one, all must join in the execution of trust, except when the instrument of trust otherwise provides. This is one side of the coin. The 49, section 49 is the other side of the coin. Because section 49 prohibits the delegation. Section 50 of the Trust Ordinance emphasizes that it should be done by all the trustees together. This principle is corollary to the principle that a trustee cannot delegate his function as is provided in section 49 of the Trust Ordinance. Thus, when there are more trustees than one, the trustees must act a body, each contributing the benefit of his individual opinion relating to affairs of the trust. This is because the beneficiaries are entitled to the collective wisdom and directions of the trustees. In all the matters, when the trustees have to exercise the discretionary powers, they must act jointly but not individually. The normal rule is that all the trustees must join in the execution of trust, and it is a legal obligation and duty required to be performed by all the trustees. When the property is vested in the trustee, the owner must be the trustee. And when there is so, it is obvious that all the trustees must join in a suit to recover their trust property. There is no reason as to why the co-trustee, who in fact stand on a higher footing than mere joint owner as regards the individuality, there is no reason as to why the co-trustee, who in fact stand on a higher footing than the mere joint owner as regard indivisibility of interest, should not be subject to this rule except when the instrument of trust otherwise provides. As we have seen Srivastava case, in Srivastava case what happened? The trust was created on the 25th of December 1978 by J, one of the original petitioner in favor of his two minor grandsons. The trustee is named in the trust deed, the settler's wife R and their son V, who was also father of beneficiaries. clauses 7, 12 and 16 and 19 of the trust deed clearly allow not only one co-trustee but any person to carry out the trust and to act for the trust provided of course such person is expressly authorized. From the document placed on the record, the conclusion is inescapable that the trustee expressly authorized N to file a petition. Moreover, the affidavit of V, who is alleged to be the registered owner of the 1029 preference shares, clearly shows that he had expressly consented to and authorized N in his capacity as such trustee to file proceedings. So it was held that the delegation to N is invalid and he is entitled under the instrument of trust to file a petition in court alone on being properly authorized as provided in the various clauses of the trust deed. All acts which trustee intend to take for executing the trust must be taken by all of them acting together. Therefore, there can be no doubt that if the validity of alienations effected by trustees falls to be considered only in the light of the provisions of the trust ordinance, in fact, that out of 3 trustees, only 2 have executed the sale deed, then the deed of sale would by itself make the transaction invalid and also would not convey the title to the other person. However, if a trust deed under which more trustees than one is permitted or appointed expressly provides that execution of the trust may be carried out not only by all but by one or more, then the matter would be governed by special provisions of the trust deed. Now in this case, Jankirama Iyer case, what happened in this case, if the trust deed under which more trustees than one are appointed expressly provides that the execution of trust may be carried out not only all but by one or more, then the matter would be governed by special provisions of the trust deed. When you see the trust deed, it is here in italic. In connection with the estate, in connection with this estate, in all proceedings to be taken, you all 3 unanimously or according to the decision of the majority shall act. Then what happened in the court? The court held that it does not mean that 2 of them only can act. It cannot be accepted that this clause allows 2 of the 3 trustees to act without joining the 3rd trustee in the actual action to be taken in the execution of trust. It is not necessary under the clause that in the matter of executing the trust, every decision must be unanimous. The clause recognizes that in some matters decision may be by majority, but nevertheless it requires that once a decision is reached either unanimously or by majority, in giving effect to that decision and in taking any given action in the execution of trust, all three must act. All three must act. Thus, read this clause conforms to the statutory provisions contained in Section 50 or Section 48 of the Indian Act and is not intended to provide for the exception to the said provisions at all. When there are more than one trustee, it is essential that all must join together in the performance of any duty which the trustee imposes upon them. Law does not recognize any such thing as an acting trustee who carries on the administration and whose decisions are merely endorsed by other trustees. Therefore, what we have seen up to now, Section 49 prohibits the delegation, Section 50 requires every trustee must act together. As an office of the trustees joint and trustees are required to act together in the administration and management of the trust. Then the situation or defense of legal proceedings must be done by all of them. It is only in exceptional circumstances that some of the trustees can institute legal proceedings on behalf of the trust. All the trustees must employ only one solicitor and incur no separate liability for costs. Thus, ordinary, all the trustees must join in the institution of proceedings, and if some of them do not wish to join or have done some acts precluding them from joining as plaintiffs, they should be impleaded as defendants. The plea of non-joinder of trustee has to be raised by the defendant at the initial stage, where the plea that the suit is bad for non-joinder was raised the first time in the appellate court, then the court, then the objection has not been held as tenable when the suit has been filed by managing trustees. Now we will move to other section, that is the section 51. Where a discretionary power conferred on a trustee is not exercised reasonably and in good faith, such power may be controlled by court. Then always, if the discretionary powers conferred on trustees, then the trustees must exercise such discretionary power reasonably and with good faith. Section 51 confers the jurisdiction upon the court to control and interfere with the discretionary powers of the trustees conferred upon him by instrument of trust or by law, when such powers has not been exercised reasonably and good faith. However, sometimes the discretionary power conferred on the trustees in the instrument of trust is in substance imperative. Even then, such powers has to exercise reasonably and bona fide, that is a good faith. What section 51 enjoins upon the trustees is to exercise the discretion in reasonable manner and in good faith. If he does not exercise such discretion reasonably and bona fide, then the court will interfere. The court apprehends that the trustees would not exercise discretion properly. It is the duty of the court to call upon the trustees on taking the order from the court. If the discretion is exercised properly as regard to the application of the maintenance of children, then the court will not interfere. Then if there's a discretionary powers given, that should be exercised by same person or the trustees jointly, that one thing. And second thing, those discretionary powers must be exercised reasonably and bona fide. The jurisdiction of the court to intervene in the discretion used by trustees is an overriding one, which can be exercised where the court considers it expedient. Now we will move to section 52 of the Trust Ordinance. A trusteeship is not an office of profit. A trustee or the executor or administrator is not entitled to have any allowance for his care and trouble unless there is a special provisions in the deed of trust. When the office of the trustee is not a profitable one, it is usual for the settlor to provide expressly for remuneration in the deed of trust or instrument of trust. And in such case, the remuneration as fixed therein can be paid to a trustee. Another case in which the remuneration can be payable is if a contract to the contrary is entered into by trustee with the beneficiary. So it is open to the trustee to enter into such an agreement with the beneficiaries regarding his remuneration before entering into office of trustee. There is no prohibition to pay remuneration to the trustee, but there is no entitlement for the remuneration on the other part. So a trustee may receive remuneration if it is provided in the instrument of trust, but it will always receive a strict interpretation from the courts. Subsection 2 that we must see now. Nothing in section shall be deemed to prejudice the right of the resident trustee actually managing the daily administration of the religious foundation that we have seen already, or we will see in the charitable trust, in respect of which the remuneration of the trustee shall not have been settled under section 108 to such remuneration as has been in practice received, provided such remuneration should not exceed 10%. Now when you see the Duke of Norfolk settlement case or trust case, in that case, the Fox LJ has held, reviewing the entire case law, that the court has an inherent jurisdiction to authorize the payment of the remuneration of trustees, and that jurisdiction extends to increasing the remuneration authorized by the trust instrument. In exercising that jurisdiction, the court has to balance two influences which are to some extent in conflict. The first is that the office of the trustee is as such gratuitous. The court will accordingly be careful to protect the interest of the beneficiaries against the claim by trustees. Second is that it is a great importance to the beneficiaries that the trust should be well administered. If therefore the court concludes, having regard to the nature of the trust, to the experience and skills of the particular trustee, and to the amounts which he seeks to charge when compared with what other trustees might require to be paid for their service, and to all the other circumstances of the case, that would be in the interest of the beneficiaries to increase the remuneration, then the court may properly do so. When a trustee is professional man, such as solicitor or auctioneer or surveyor, he is entitled to charge for his service to the trust in the absence of any express provision in the deed of trust. Generally, they are not, trustees are not entitled for this one, but there are circumstances where if they use their expertise knowledge, then they can, some extent, they can ask for some sort of remuneration. Before acceptance of the trust, so trustee may enter into a separate or special contract for remuneration with the beneficiaries if they are sui juris and competent to contract. Such an agreement must be distinct and clear and must have entered into by the beneficiaries with a full knowledge of their part that without such agreement no remuneration would be payable to trustee. However, there should not be any sort of pressure or undue influence in bringing about such agreement, and in such case, such an agreement can be challenged in the court of law. Now we will see section 53 of the Trusts Ordinance. A trustee may not use or deal with trust property for his own benefit or for any other purpose unconnected with the trust. That is a section 53 of the Trust Ordinance. They should not use the property, or the trustee should not use the property or deal with the trust property for their own benefit or any other purpose not connected with the trust. Therefore, section 53 prohibits a trustee from making any profit by virtue of his position as a trustee. Section 53 prohibits two things, namely, one is a trustee may not use or deal with such trust property for his own benefit, or second is he may not use it for any purpose other than that of the trust, unconnected, that is unconnected with the trust. Section embodies a rule of equity that the trustee holding the trust in fiduciary capacity does not make his personal benefit by his management of trust. This prohibition is based on the principle that a trustee should not place himself in a position where there is a conflict between his personal interest and his duty as trustee. Waterman's Wills Trust case. In that case, if a trustee having beneficiaries' money in the pocket chooses to place it on deposit in his own business, in other hand, to lend it to himself, the court will without hesitation charge him with the interest whether or not he has made a profit, because he has empowered or employed the trust money in his trade, and that the court will not allow unless charging clause depends with the usual penalties. Therefore, what we have seen in this one, a trustee having beneficiaries' money in their pocket, either they can deposit in own business or lend it to himself. The court will charge the interest whether or not he has made profit. In the bribery case, now that's taking bribery by trustee. A trustee who invests trust money after accepting a bribe must account to the beneficiaries for the trust money as well as the amount of bribe. That was decided in the VII case, the old case, but very important. If a trustee accepting bribe, then the trustees are accountable, even not only the trust property or trust money, but also to the bribe what they have taken. Now 54, section 54 here, no trustee whose duty is to sell trust property and no agent employed by trustee for such purpose of sale may directly or indirectly by same or in interest therein on his own account or as agent for third person. In terms of section 54 of the trust ordinance, the section 54 lays down that the trustee for sale of trust property shall not directly or indirectly buy any trust property or any interest therein. He cannot do so either on his own account or on the account of agent of third party. An agent appointed by trustee to undertake the sale of the trustees for and on his behalf has been placed under similar disability. The alienation of trust property by trustees to one of the near relatives of one of the trustees is void. If a trustee or his agent buys the trust property, transaction is voidable at the instance of the beneficiaries, and they may demand reconveyance of such property. But where there are more than one beneficiary and all do not consent, the remedy of descending beneficiary is to demand resale. If the agreement for sale was entered into prior to the trustees becoming trustees of the trust, the trustee can complete the sale as it does not violate section 54. Wife of the trustee is not prevented from purchasing from trustee provided the purchase was not for the benefit of her husband trustee. If it is purchased by wife, it's all right, no problem. But if such purpose is beneficial to the husband, then it is prohibited. A partner of the trustee or partner of a trustee or other person from whom the trustee may derive an interest cannot purchase that property or trust property. Finally, we will see section 55. Section 55, no trustee or no person has recently ceased to be a trustee may without permission of the court buy or become mortgagee or lessee of their trust property, any part thereof. Such permission shall not be given unless the proposed purchase or the mortgage or lease may manifestate for the advantage of beneficiary. Section 55 lays down that the trustee cannot buy the interest of a beneficiary without the permission of the court. Such prohibition applies also mortgages and leases of trust property and any part thereof. Moreover, the permission to buy will not be given by the court unless it is satisfied that the transaction is for the benefit of beneficiary or the advantage of beneficiary. Position of the trustees for purchase is also same. The second paragraph to section 55 states that the trustee whose duty is to buy or obtain a mortgage or lease for the beneficiary is also prohibited to buy the trust or obtain mortgage or lease of the property or portion thereof for himself. When a beneficiary seeks to challenge the purchase by trustee, he must approach the court within the reasonable time. It can be presumed that the beneficiary stood by the transaction when he remained silent for long and transaction was fair. When the conduct of beneficiary is such that they acquiesced in the transaction of trustee, then even where they approached the court without making any delay, transaction can be held to be valid. Then they must go on time without any delay. And also if they agreed for such transaction, thereafter beneficiary can't go and challenge it. Finally, section 56 of the trust ordinance, the trustee or co-trustee whose duty it is to invest the trust money or on mortgage or personal security must not invest it on mortgage, buy or on personal security of himself or one of his co-trustees. Section 56 lays down that the trustee or co-trustee whose duty is to invest the trust money or the mortgage on personal security cannot lend one of themselves either on mortgage or personal security. The prohibition contained in section 56 from lending any trust money on mortgage or on personal security for himself or to any trustees. It is a specific instance in which the trustee is prohibited by using the trust money or trust property for his own benefit. That is the end of disability of trustees. Thank you.